Welcome to Early Returns, hosted by Jan Barron, a partner of Holtzman Vogel. This podcast examines law and politics and seeks insights from political players in elections, lobbying, media, and the law. Now, let's join our host, Jan Barron.
Welcome back to Early Returns, a podcast about law and politics. I'm your host, Jan Barron. Our producer is Jody Mayer Piazza. This year, the 4th of July followed an unusual and likely historic week of political and legal events. The Supreme Court of the United States ended its term with a slew of news-making decisions, some of which affect former President Trump, his pending legal cases, and the 2024 presidential election. The court itself is on vacation. Perhaps the justices are pondering how and why the court has become embroiled in the nation's political and cultural wars and lost so much of the public's confidence. Moreover, a week before July 4th, President Trump and President Biden held their first campaign debate. It is widely considered to have been a debacle for President Biden, who displayed repeated senior moments. To help us sort out these events and their significance, I'm delighted to welcome back Politico's senior legal affairs reporter, Josh Gerstein. In his Politico biography, Josh is described as follows, quote, "While not a lawyer, Gerstein spent more time in courtrooms and more time reading legal pleadings than many members of the bar," unquote. I couldn't agree more. For over 20 years at ABC News and now at Politico, Josh has covered and reported on virtually every legal case that involved a politician or a political controversy, including the prosecution of Hillary Clinton's campaign fundraiser, the trial of former presidential candidate and Senator John Edwards, the Mueller-Russia investigation, the Dobbs case, which reversed Roe versus Wade, and the many Trump cases. He is the rare breed of top journalists who cover legal affairs, understand the law, and translate what is seen into clear articles that are understandable to readers. Last year, Josh spent a semester as a fellow at Harvard's Kennedy Institute of Politics. Harvard also happens to be his alma mater, where he was a classmate of sorts with our last Early Returns guest, Canon Shanmugam, who in fact is a lawyer. Well, Josh, welcome back to Early Returns.
Hey, Jan, it's good to be back with you again.
Well, this has been quite a time for politics and reporters. I mean, you've had so much to cover already in 2024, but particularly recently with these Supreme Court decisions and covering the Supreme Court in general. I thought we could start our discussion with the one case that seems to have gotten the most attention. It came down on the last day of the court's term, which was Monday, July 1, and it involved whether or not a president, an ex-president, has immunity from criminal prosecution. You've written about it. You've covered it. How would you describe that case and what it was about?
Well, the case is about one of the 4 criminal cases that is pending against former President Trump. We should say any one of which would be historic because no sitting or former president has ever faced criminal prosecution. I think one of them may have gotten a speeding ticket, and that's about all that any current or former president has ever incurred. So it really comes out of one specific case. That's the case in Washington, D.C., where the special counsel, Jack Smith, is charging former President Trump with a very broad conspiracy to overturn the results of the 2020 presidential election. So it's a fascinating case from Politico's point of view and from a political point of view because you have the historic element of it being unprecedented. You have the historic element of the events of 2020, the defeat of President Trump in that election, and obviously the riot, the Stop the Steal, and the effort to prevent the certification of the election. And that would be enough. And then on top of all that, you have the fact that former President Trump is running for re-election again right now. And the legal proceedings are going on as the political campaign goes on. So in the middle of all that, you have the Supreme Court deciding to get involved in the case after, I think, a period where it seemed like they were not that interested in taking up Trump-related disputes. I think, you had a Republican appointed majority on the court, and like a lot of Washington establishment conservatives, I think they were pretty eager for a while to put Trump in the rearview mirror. But the arguments that he raised about presidential immunity and that his attorneys raised about this case possibly intruding presidential immunity, I think proved to be irresistible to some members of the court who are particularly concerned about executive power and executive authority. And so you had the court take this case up, agree to take it, I believe, in February. They heard arguments on the last day of argument of the term, April 25th, I believe it was, going from memory. And many people thought we'd get a very quick decision. We didn't. We got the decision on the very last day of decisions for the term, even stretched out a little bit beyond when the court usually hands down decisions. And the ruling, if you read through it, it seems like it's one of these split decisions, split the baby, a little of this and a little of that. The conservatives, the Republican appointees, by and large, line up on one side, and the liberals, the Democratic appointees, line up on the other. And it looks like kind of a qualified victory for Trump at first glance. And I think as you swish it around in your glass a little bit, it seems more like an unqualified victory for Trump. That's my bottom line take on it after having read through it a few times and written about it and talked to people about it. It's a pretty big victory for Trump. It probably, as a political matter, by which I mean in terms of things that are going to happen before the election or before Inauguration Day 2025, I think it kills the case in which the dispute arose, and it may well indefinitely tangle the three other criminal cases that Trump is facing right now.
Well, this is one of the complications of talking about this legal subject, is that everything is unprecedented. In fact, the Supreme Court has never had to decide whether there is immunity in a criminal prosecution. Now, by the way, in the context of other government officials, there is a pretty broad concept of immunity for government officials doing their official acts and protecting them from lawsuits. And here I do agree with you that the court was trying to avoid having to deal with any of these Trump lawfare cases, but they've been forced. They basically have been forced to take a look at this stuff. And you mentioned that they granted certiorari in February, which is just before they issued their decision in another case involving Trump in March, which was the 14th Amendment issue of whether or not a state could prevent Trump from appearing on the ballot because he allegedly was involved in an insurrection against the government of the United States. And they unanimously came down with a decision then in March saying that the states cannot prevent a candidate from appearing on the ballot for that purpose. And then there's a third case that came out just last week or the week before this immunity case, which pertained to the demonstrators, the rioters of January 6th, which basically threw out potentially hundreds of prosecutions, which were based on an obstruction theory of dependent on a federal statute, which the court said really doesn't apply in that particular instance. So here we have the court wanting to avoid these things, but they can't avoid them. They have clear implications for Mr. Trump and for this presidential campaign. With respect to this case in D.C. that you mentioned, where this immunity decision arose, there were 4 charges in that case, as I recall, 4 counts. What happens in that case immediately going forward? Everything is on hold. There's a judge. They've already had all kinds of arguments. The trial has not started, but you've got 4 counts here. What has to happen? What does the judge have to do? What does the prosecutor have to do?
Well, under this immunity decision that came out from the Supreme Court, it actually requires the judge to do a very in-depth analysis of not just the indictment, because, that's a relatively easy exercise. Maybe easy is exaggerating it, but it's somewhat straightforward. I think it's like a 45-page indictment. You get the indictment, you look at it, you get the briefs from both sides, get your black tip marker out and start redacting. Judges do this sometimes for various reasons. In other cases, they say, look, this particular allegation has to come out of the indictment because it's not appropriate or it's scandalous or something there is privileged or some other court has ruled it can't be done. So I think a judge could do that. Obviously, the judge here, Tanya Chutkan, didn't think she needed to do that. And the DC Court of Appeals, the DC Circuit Court of Appeals, did not think she needed to do that. Now the Supreme Court has said she did. So that's one complication, and that there may be disputes, and there will be disputes about what parts of that indictment relate to official conduct. The Supreme Court set up a kind of complicated levels of tests here. Core constitutional responsibilities are completely off the table and can't be anything that a president did that was connected to that, which sounds like foreign policy and maybe military matters, although the Supreme Court didn't spell out exactly what they mean by that. I don't know. The president signs bills. There's a lot of things in the Constitution. But anyway, they are supposed to just take that stuff out right away. And then official acts, which is a little more malleable because you could say the president has some duties under many laws that, or maybe every law that the United States has, depending on how broadly you want to read it. And on those official acts, the judge has to determine that they were official as opposed to private or political, and then decide if, they could be part of a case or part of the evidence in a way that has no risk of impinging. I think the phrase is poses no danger to the president's executive responsibilities, which I believe comes from a civil case about 40 years ago involving President Nixon. And so that's the test that the judge has to apply. Another layer of complexity, I talked about the redacting with the pen of the indictment. That would be relatively simple to do once you have the briefs and arguments from both sides. The Supreme Court said that's not good enough, and that the judge has to go through the evidence that's going to be presented in the case and sift that into separate buckets, maybe 3 different buckets, with this complicated test for the middle bucket of does it impinge on a future president's execution of his responsibilities. And so it's a lot of work for Judge Chutkan to do. It's a lot of briefing for the sides in the case to do. I'm not totally clear how the evidence part of it would work. How do you know that what's presented at some kind of hearing would be exactly what's presented at trial? So she might have to make judgments at trial on the fly. What I can tell you is from a political point of view, some of Trump's opponents have seized on this, even though they're very disappointed in the Supreme Court's decision that there is a form of immunity for presidents. I think it's a pretty broad form of immunity. And they are hoping that this evidentiary hearing results in or becomes a quote unquote mini trial where a lot of the evidence against Trump could be aired. People who are under subpoena, perhaps, to come testify in the trial would testify at this hearing. It's not going to take place next week, I don't think. So we're talking probably about it taking place fairly close proximity to the November election. And so this has become sort of an unsatisfying second choice for Democrats and some Republicans that don't like Trump of how to air these allegations. Trump already went through one trial in the middle of the campaign on these hush money charges in New York. But this is something that I think is a far more substantive case. And, it could inject the hope among the Trump critics is it will inject discussion of his activities in 2020 that I think most Americans did not approve of into the political discourse with weeks to go in the presidential campaign. So that's sort of the political fallout that we could see if we have this hearing. There are no cameras in the courtroom unless something extraordinary happens. Federal courts don't allow cameras. There was a little of it during the pandemic, and they basically don't allow them anymore. So if it gets in the public bloodstream, it's going to be through old-fashioned newspaper-style reporting and so forth. And there might be videos and stuff that come out. I've watched a lot of the January 6th trials for lesser defendants, and they are replete with video. a number of the people that went up to the Capitol that day, not a number, probably a majority, were making souvenir videos of the rather reckless and stupid and dangerous things that they did. And those have proven to be quite useful evidence for the prosecutors, in addition to security cameras and police body cameras and all kinds of other. They've got about 13 angles on every single incident that happened there during a pitched battle that went on for hours and hours.
Well, one of the only examples that the court gave in its opinion about something that was completely immune and out of bounds for prosecutors were discussions that President Trump had with the acting attorney general of the United States at that time during all of these sessions about contesting the election. That's a pretty significant area because he was dealing with the Justice Department, trying to get them involved in reviewing whether there were any errors or illegal voting that was going on in the election. And that was specifically mentioned in the indictment from Mr. Smith. So it seems to me that if that's completely out of bounds and it's in the indictment, they're going to have to do something about the indictment and not just black it out. But it may be that, first of all, Smith would have to go to the grand jury and basically re-indict the president. He might have to he has that power and that option. And then if they don't do that, or even if they do that, they're going to have to review all the evidence that the prosecutor plans to introduce in support of whatever indictment is sustained. And it seems to me that that really is going to help the defense quite a bit to say, okay, well, this is what he plans to introduce. And of course, they're going to argue as to whether that is subject to immunity. But even if it's not subject to immunity, it really prepares the defense in terms of any ultimate trial. This does seem to just overturn everything in that particular case, and it's going to take months to sort it out, months at least, by which time we'll know whether or not Trump has been elected or not, or whoever the opponent's going to be, assuming it's President Biden, but that's up in the air these days. I think one of the interesting immediate effects of this decision is not in these federal prosecutions, but it's already having an effect in the state prosecution, the hush money trial that you mentioned. There was going to be a sentencing of President Trump on July 11th, and now that has been postponed because they have to unpack the effects of this immunity decision in this clearly non-federal state trial under state statute regarding record-keeping laws in New York. What do you think is going to happen there? What does that mean?
So there's going to be a delay in the sentencing. Any delay in the sentencing at this point causes a certain degree of complications because of the political schedule that we already mentioned. This is not any defendant. This is somebody who's running for president of the United States and is on the verge of being formally conferred the Republican nomination for president of the United States. So it's just not that easy to sort of pick another, what date is good for you, Mr. Trump? So that's a problem. I think in the end that New York hush money case is probably one of the ones less affected by this ruling, because while Trump's lawyers did try to argue that there are some official aspects or might be official aspects to the case or the evidence, it's a vanishingly thin argument. I think he did do some things in the Oval Office and he signed some checks and some things did go through his taxpayer paid secretary there at the White House, but it's really going to be hard to argue that this is official. And even if official, somehow it seems like it's got to be on the side of the line that isn't probably going to be a big problem for future presidents, like carrying out their duties. But the court has said you need to do that analysis. That's what the Supreme Court seems to have said. It wasn't done in this case because we didn't have this opinion. And so I think the forthcoming motion from Trump that they've indicated they're going to file is going to say, we need to do that sort of analysis of, what the impacts are and are things that were alleged or even mentioned at the trial. Are they some sort of official act that maybe needs to be handled in this way? I think at the end of the day, the judge will come down and say, this is a harmless error type situation for that case. There's nothing tweaking the evidence and having one answer different is not going to change the outcome.
Well,
I think a bigger problem could be down the road for the Georgia case, which is replete with things that Trump can argue were official, sending his chief of staff to do stuff, things through the Justice Department and so forth. That's going to have every bit as much trouble as the case in Washington, D.C. as a result of this decision.
I think there was one element in the New York case that may be problematic, and that is the testimony from his former White House staffer, Hope Hicks. I don't recall what testimony she provided that was important enough for the prosecution, but that will raise the question of, is it appropriate to have a former White House staffer come and testify about what she knew and what she discussed with the president in the White House?
Right. She wasn't the only one. There was another woman, I think her name is Madeleine Westerhout, if I am remembering correctly, who had, I believe, worked as an Oval Office assistant of some sort. And they each had some peripheral involvement with some of the issues. I don't think any of them were clued in on the overall scheme that was alleged in the indictment about the hush money and so forth. But they handled envelopes that were coming in and out, things along those lines, and provided some factual connections. But I agree with you. So it's going to require some assessment by the judge. And it's probably much smarter for the judge to deal with it now than to not deal with it, go ahead with the sentencing, and then, have to deal with this case again in a year or two coming back to him on some kind of an appeal. But it chews up more time. It drags things out. And that's been part of the Trump strategy all along. And so that's why I think that this decision is sort of an unmitigated, unqualified success for him, because it just sets in process all kinds of wheels that are going to take a long, long time to turn in pretty much every one of these pending cases. And for Trump, that's sort of the best case outcome that he can hope for.
Well, you've mentioned 3 of the 4 cases already that are pending. The 4th one involves the classified documents that President Trump retained at Mar-a-Lago. And I think he's charged with obstruction in that case as well. And of course, I don't know what the implications are of this immunity case there.
I think it has probably some pretty significant, substantial implications. At a minimum, the judge is going to have to do the same kind of analysis, because there are some aspects of that case that I think do stretch back to when he was president. I mean, the thrust of the case is about things that he did after he was a private citizen again. Obviously, he's charged with obstruction of justice in that case, with trying to thwart a federal investigation into how these classified documents ended up at Mar-a-Lago, his estate in Florida. But I think they've used evidence, and they've talked about evidence that goes back into his presidency about his ways of handling classified information, his ways of, believe it or not, just boxing stuff up. I don't know. He's boxing stuff up at the White House. It's a mixture of official records and personal records. Its testimony is coming. One of the defendants in the case is a former Navy valet of his from the White House. Other aides are expected to testify. I don't have the full list of names, but I think a couple dozen of them are former officials that would talk about what his practices were. The way I read this analysis, for the president of the United States, and this appears to be the only person it applies to, maybe it applies to the vice president too, before any of that testimony comes in, the judge has to look at it or get a proffer of what it's going to be and go through this assessment of whether it could prompt a future president to have some doubts about carrying out his duties. And then, Jan, we didn't mention this, but Justice Barrett's opinion in that immunity case says several times that Trump would be entitled to appeal that decision to the appeals court. I don't think it says to the Supreme Court, but you can always try the Supreme Court. So the sort of cul-de-sac that these cases have gone into now that could result in, really, some people I've talked to said they think it could be a couple of years before these issues are resolved, or even in a position where those cases could go to trial because of this potential for all this litigation, for sifting through the evidence and potential testimony, and then pretrial appeals. It's quite an imbroglio that I think the court has created with this ruling. And I want to tell you one other funny thing about the ruling. This is sort of a legal technical point, but I think you'll appreciate it as someone who's interested in the privileges and the fights between the branches that we have in this political legal context sometimes. This is a point Justice Barrett also makes in her concurring opinion. The weird part about this opinion is that in some respects, it now gives broader protections to the president than it does to members of Congress, to senators and members of the House. And not to tweak the textualists on the Supreme Court too much, but there's an actual section in the Constitution that accords certain legal immunities to people that are members of the House and Senate. There are words right in there. You don't have to interpret this penumbras or any of that. There's words. It says you can't be interfered with when you're going to or from the House of Congress, and anything you say in the official proceedings of Congress, you have immunity for. There's no such clause or section for the president. And so I took Barrett to be saying that it was a little odd that the court was suggesting in, say, a bribery case that some evidence that could be presented against a congressman would be off limits against a president. It is a perplexing result, but I think that's the product of the reverence with which some members of our current Supreme Court hold not just the executive branch, and not so much the executive branch because they mess around with federal agencies all the time. It's really the office of the presidency and some up there. I guess I'm looking at Justice Kavanaugh in particular, but also Roberts, maybe Alito as well, who have this vision that a president has to be able to take swift and decisive action on all sorts of matters, and that if he hesitates for a moment, the nation is lost. And I really think that that's their view of the world based on experience, and we see that playing out in this decision.
Well, the Constitution is very, very complicated in terms of how it deals with the three branches of government. And I always like to point out that Article 1, which is supposed to be the most important article, is about Congress and not the president. And of course, Article 3 is about the judiciary. But in addition to the immunities that the Constitution provides to members of Congress, there's also something called the Speech and Debate Clause, which prevents members of Congress from being questioned about any of their official actions. And this has come up in litigation. Somebody is accused of doing a bribe or something improper while on the floor of the House or on the floor of the Senate, and while they're considering legislation or something else, and you want to ask them a question about it, their lawyer is going to say, no, you can't do that. I'm protected by the Speech and Debate Clause and so forth. So, yeah, there are all these wrinkles, and we're seeing them come up. Now, you mentioned Justice Barrett. This was a 6-3 decision, the immunities decision. By the way, the case involving putting Trump's name on the ballot in Colorado was unanimous. That was 9-0. But here you see the partisan split between the conservative wing of the court and the liberal wing of the court. I want to ask you about what your observations are about the Supreme Court, because they're being subjected to increasing scrutiny and controversy, not only because of these decisions, but we've just gone through a period of almost a year where the ethics of some of the justices, like Clarence Thomas and even Justice Alito, have been questioned over whether or not their spouses were present on January 6th somewhere, whether their spouses are flying inappropriate flags at their homes. I mean, this is getting a little peculiar, and you have this drumbeat, and we are now 2 years since the decision in the so-called Dobbs case, which reversed Roe versus Wade on the abortion issue. And that's something that you were quite familiar with, because a couple of months prior to the official release, you received a copy of the draft decision, which did not change much between the time that you received it and the time that the court handed down its decision. And you wrote about it. It's an unprecedented leak from the Supreme Court. It's unheard of for some information of that sort to get out. And I really have a couple of questions that I hope that you could address. One is general in terms of what is this doing to the reputation of the court? How does it undermine their own stature and credibility and reputation? And then secondly, I'm very curious as to what effect in particular this leak had on the court. How have things changed, not just in terms of security of draft documents, but the interpersonal dynamics of the justices and their clerks and the staff and so forth. So I know I've thrown out a lot there. I'll leave it up to you to unpack it the way you feel comfortable.
Well, I think it has been a rough patch. I don't know if 2 years is more than a patch. I'm not sure what the exact duration can be, but it's certainly been a period where the court's reputation has been challenged and I think in the eyes of many people sullied. Some of it maybe has to do with the leak of the Dobbs decision. A lot of it, I think, has to do with the ethical allegations against Justice Thomas and Justice Alito. Some of it has to do with dynamics involving the court's decisions. I would like to tell you that I think that the Dobbs decision was the most important thing. At the end of the day, the court's decision to overturn the federal constitutional right to abortion after 49 years probably matters to more people than the leak of the decision. A lot of people probably don't even know about the leak, but they know that, the state that they live in has basically implemented a near ban on abortion. So I think that the court's reputation has suffered over the last couple of years. Some justices are particularly concerned about it. I thought it was interesting, Jan, there was some leaked audio a few weeks ago from conversations that a documentary filmmaker had with Justice Alito and with his wife and with the Chief Justice at some events that are hosted by the Supreme Court Historical Society. I should caveat it by saying that this woman essentially misrepresented herself as a conservative activist whose views were either in sync with those of the Alitos or what she perceived their views to be, or maybe even a little more radical than them, trying to goad them on. So there's something here that is a little bit atypical journalism in the current era. But I thought the comments were pretty interesting. Justice Alito said he thought the loss of trust in the court was a big problem. I didn't know that he actually felt that way. I thought he thought it was a lot of noise being made by people on the left and dismissed it. And he did seem to think it was a problem. He blamed the media for it. He said the media characterizes these things unfairly and exaggerates, sensationalizes them. And then there was a lengthy exchange that just at a fairly recent event with Mrs. Alito, where she defended these flag incidents that you referred to and said she planned to keep on doing it, seemed to make some comment that she was doing it to get in the face of LGBTQ activists or whatever, which seemed again like a strange thing for someone to be saying. But also we should mention that I don't know if any of them really knew that they were being recorded in addition to somewhat misleading questions that were being asked at a social event. So it's still a mess that the court is trying to work through. We did have a pretty big development this term, which was it appears that the Chief Justice persuaded the other justices, all 9 of them, all 8 of his colleagues, to sign on to an official code of conduct for the court that addresses both sort of personal ethics issues of finances and broader questions of recusal from cases. And that's something the court had, I don't want to say it had refused to do, but it certainly had failed to do in prior years. And there was some reporting from the Washington Post a year or two ago that proposals like that had been raised and they couldn't get a consensus to do it. And somehow, amidst all this controversy about gifts and trips and so forth, Roberts did manage to get his colleagues to adopt this as a formal code of conduct. The critics will immediately point out there's no enforcement mechanism in this code. So what does it even mean that it's a code of conduct? And I noticed when they released it that it was in some respects weaker or less detailed than some principles about ethics they had released about 6 months earlier. So it's an imperfect resolution. It does indicate that probably every justice or close to every justice on the court is somewhat concerned about the court's public reputation and at a minimum perceptions that the justices are acting unethically, or perhaps a more difficult perception to overcome that the justices are acting for partisan political reasons. And that's what really drives judges nuts. I was at a meeting with some lower court judges just a few weeks ago, and they made pretty clear that of all the things we reporters do, the mistakes we make, the sensationalism, that's not the thing that bugs them the most. What bugs them the most is that, when I put their name in an article, sometimes I write, this person's an Obama appointee or a Trump appointee or a Reagan appointee. And apparently that is completely infuriating to them. And so I assume that sentiment extends all the way up to the Supreme Court. But even some justices like Justice Kagan have said, don't try to tell me a lot of cases are unanimous, because everybody knows what the big cases of the term are. And many, many times they come down 6-3 or 5-4. And when the justices split that way, many, many times they split along ideological lines. So when that's what you get in a Dobbs decision or in a Trump immunity decision, you really have to excuse rational actors that are not familiar with all the court's workings from leaping to the conclusion that maybe partisan politics has something to do with what the court is doing. And I know that's offensive to the justices, but it doesn't seem to many of us on the outside like an entirely irrational thing to at least discuss.
Well, I think there's a tension between the fact that judges have different views about the law and the fact that judges have a self-image that can be in tension with the different views that they have. And we can translate that into partisanship, or we can just say, look, you have a difference of opinion on whether or not the Constitution should be interpreted a certain way, or whether or not the president has the powers to do something. And it just winds up being a ideological difference, which is translated into partisan effect in the sense that presidents still are the ones who have to nominate the judges, and they tend to be either Republican or Democrat. And I would just point out, as a lifelong Republican, there were very few of these types of complaints when Republican presidents kept appointing justices who seemed to go along with their liberal Democratic colleagues on a pretty consistent basis. As you know, I've litigated several Supreme Court cases, and the ones that I lost was the result of a 5-4 decision in which 3 of the 5 justices had been appointed by Republican presidents. They're all gone, mercifully. And when that changed, then all of a sudden some of the campaign finance cases turned out completely differently. Why? Because, you had different philosophical opinions about how to regulate money in politics, and the justices tended to be more in sync with the ideology of the presidents who appointed them. In this Supreme Court episode of the leak, was there an investigation, and by whom? Were you ever questioned about that?
So there was an investigation that went on sort of behind the scenes. It was done by the Supreme Court marshal. I think the Supreme Court was uncomfortable having outside law enforcement handle it. That's interesting in and of itself. I bet if you went in and grabbed a bunch of items out of the Supreme Court gift shop and ran out the door, they'd be happy to have the U.S. attorney prosecute you. But they felt that on this matter, it was sensitive enough that it should be handled internally. I'll also say, from speaking to people at the Justice Department, I did not discern a great appetite on their part to investigate this. And in fact, at the outset, people indicated to me that they didn't really think that there was a basis for a criminal investigation because there was no clear statute that had been violated. You can always come up with a tenuous connection to something that somebody theft of services or something if you want to do it. But if you don't want to do it, there was nothing obvious to cite that had been broken in somebody releasing information from the Supreme Court that the court normally keeps confidential. I should point out this also happened just a couple of days ago. We had an opinion released on the Supreme Court website. One news outlet, Bloomberg Law or Bloomberg News, managed to scrape it or grab it while it was up there. The court is saying it was inadvertent. I don't have any reason to dispute it. What I find a little funny is that the court hired consultants to tighten up all of its cybersecurity and digital security and physical security practices over the last few years and spent an untold sum of money on that because the court doesn't tell us how it spends its money. And yet this mistake or whatever happened, even though you would think there should be firewalls in place that would make it very difficult to get a active decision, get a decision that isn't supposed to come out on a certain day to the public web server on a day that decisions are being released. Yet that's exactly what happened. In terms of the investigation, there are some things I probably can't say about it, but I don't think there was any effort to talk to us at Politico or to me or my colleague Alex Ward, who worked on the story with us as part of that investigation. I would also note that when Justice Alito spoke with that filmmaker a couple of weeks ago, or this may have been in his earlier conversation with her a year ago, he said something about that the court had limits in its legal authority to what it could do and what it couldn't do. And it couldn't, for example, subpoena people's phone records. I think there were also concerns that the court hadn't really prepared for a situation like this. And so when you go work at the CIA, as I'm sure you know, Jan, you sign documents 8 ways to Sunday for access to this and access to that and secure compartmented programs. And if people eventually get prosecuted years down the road, we get these grainy copies of stuff that they signed in the 1970s saying they understood all the rules. I'm not sure the court was really doing that before the leak episode a couple years ago. There were some general conversations, I think, with clerks about don't do this, don't do that, don't talk about what happens here. But the more detailed kind of discussions like, can I work on briefs or an opinion while I'm on an airplane? I don't know. I don't think anybody ever discussed that. I'm not suggesting that's what happened in this instance, but I've heard stories since then of those kinds of things going on that people don't know. And then you have the justices themselves, as we've also discussed, the rules around their conduct are malleable and often driven by tradition more than letter. And how careful are they with the materials that they use? I mean, it's not an institution that has operated like the National Reconnaissance Organization for the past decades. And so, if anything, it's antiquated in the way it does things with a lot of paper and so forth. So the court has tightened things. If you go up to the court now, if you look carefully, you'll see a lot more places where people have to swipe badges to get in to the building and to get into certain hallways. And they say that they've tightened up their tracking of how the court's internal documents are handled. But I think the evidence from the last few weeks is that the jury is still out on how successful those efforts have been. Although I'm sure they've scared the heck out of the employees about being held responsible for something like this.
Well, one of the few things that the court and individual justice can do is to basically ruin the reputation of a law clerk who has failed them in some way. It may not be a legal consequence, but it's certainly a personal and professional consequence. It doesn't happen very often, but it has happened when somebody has done something as a failure to the court, but it's very rare. And I take it that any more information about the leak and how you got your hands on the opinion, you're saving for your autobiography or some other occasion and not this podcast. Is that correct?
Well, we're still trying to be careful. I don't think that all the potential consequences for that have necessarily evaporated. And so I think probably you're not going to hear from us for a considerable period any more details about that story. But I've said before that I do think probably some of this will come out with the passage of time. Secrets don't tend to stay secret either in Washington or Hollywood or anywhere else for very long these days. And so I think that it will probably be something where people will eventually hear a bit more about it, but there's nothing imminent that I'm aware of.
Well, thank you for sharing what you have shared with us. And I know that you're about to embark on a vacation. I assume you won't be spending much time reading briefs the way your bio suggests. Will you be reading anything else that you might want to recommend to our listeners?
Yeah, so it's interesting that you bring this up. I'm going to be trying to catch up on a book that was written by one of my former colleagues at Politico, who now works for a news organization called Notus. I'm not sure how you pronounce it exactly.
Oh, yeah.
Or Notus. Maybe it's Notus like POTUS. And his name is Byron Tao, and he has written a book called Means of Control. And basically, he's someone who covers sort of the data industry, and he's sort of explored how the American surveillance state operates, and that it operates in a way very different from surveillance states in places like China or North Korea. The one in the United States, for largely historical reasons and some legal reasons, doesn't really permit the level of direct intrusion by the government into the lives of everyday citizens. And in the United States, the way the government does surveillance is by having private companies do it for them. And every time you or I open our Gmail or our iPhone or walk around anywhere with our Google Maps timeline activated, we are giving a tremendous amount of data to marketers. And I think people are increasingly aware of that they go on the internet. My dad has a story he likes to tell about doing some search for an obscure religious figure for some article he was working on, and then suddenly being served up religious dating websites for the next 6 months, which is not something he would have interest in for a variety of different reasons. He's married and he's not religious. So we all know that goes on. And what Byron really explores here is how the government is able to use that for good and ill to track people, to track their activities, to track their thoughts, to track their purchases, to investigate crimes, and even potentially to go after dissidents and do other things that I think people would be concerned about. And it's sort of this conflagration of how the government and private industry works together. It's an interesting critique because I think it raises things that are of concern to people at both ends of the political spectrum. Just to bring it around to the Supreme Court again, we saw cases this term talking about the role of government in policing what large data companies do, basically the social media firms, and whether the Biden administration had leaned on them too hard to take down certain content. And at the same time, we had a pair of cases involving Republican-led governments in Texas and in Florida that had legislation that wanted to sort of micromanage the operations of social media websites and what kind of posts should go up and come down. So you had those impulses from different points on the political spectrum, all being funneled through these private companies that so many of us use to live our lives on a daily basis. And it really does create the potential for problems. And that's something that Byron explores in the book, which I've only just started on, but it's something that I've set aside during these hectic last few months to read when I had a bit more of a chance, because I think it's going to be a big issue going into the future as people become more and more attuned to it.
Now, what's the title of the book again?
It's called Means of Control.
Means of Control.
How the hidden alliance of tech and government is creating a new American surveillance state.
All right.
And if people are looking it up, Byron's last name is spelled Tao. It's Tao. It's spelled T-A-U. But it's worth checking out, I think.
Well, and the Supreme Court has ducked a lot of these issues in this particular term. We don't have enough time on this session to get into that, but we certainly will keep an eye out on the agenda for the court. I suspect, like you, that this is a topic that is going to grow, and we're going to have more reason in going forward to get together again, perhaps narrow our conversation to that subject matter. But Josh Gerstein, thank you for your reading suggestion as well as your insights on law and politics. Thanks also to our producer, Jody Mayer-Piazza, and to the Holtzman Vogel Law Firm for its support of this program. Any opinions expressed on early returns are those of the host, that's me, and our guests, like Josh, and do not necessarily reflect the views of our sponsor or their clients. All of our episodes are available on Buzzsprout, as well as other streaming platforms, including Google, Apple, and Spotify. I hope you will join us again on the next episode of Early Returns. Thank you for listening and have a good day.
Thanks for joining Early Returns, Law and Politics with Jan Barron. We hope you will join us for future episodes, which will continue to bring you voices and insights from the people engaged in our political landscape.